Okay, I show 10:30, so I hope we are now actually actively running live. Thank you all for attending today. This is the June meeting of Indiana's Interstate Compact State Council. I'd like to thank all of you for taking the time to participate this morning. And if we could, I want to take just a couple minutes for the benefit of anyone who might be watching the live stream and have the members go through and introduce themselves and the agency that they represent. I'll go ahead and call on you since you don't know the order that you're appearing in my screen. I'll start with Laura Berry.
Good morning, Laura Berry, Indiana Coalition Against Domestic Violence.
Thank you. Bernice Corley.
Good morning, Bernice Corley, Executive Director of the Indiana Public Defender Council.
Thank you. Chris Naylor.
Good morning, Chris Naylor, Executive Director, Indiana Prosecuting Attorneys Council.
Thank you. Joel Gruber.
Joel Gruber, Indiana Department of Correction Parole, Deputy Compact Administrator.
Thank you. Senator Sandlin.
Hello, Jack Sandlin, Indiana State Senate.
Thank you, Senator. Judge Kenworthy.
Dana Kenworthy, Indiana Council of Juvenile and Family Court Judges.
Thank you, Judge Kenworthy. You were a little faint when I heard you, so I don't know if you have to speak up or yell into your microphone, but I got you. And last, Mary Kay Hudson.
Good morning, I'm Mary Kay Hudson. I'm the Executive Director for the Indiana Office of Court Services, and I serve as Indiana's Commissioner for the Adult and Juvenile Compact.
Thank you all very much. That also constituted your individual test of whether or not you can unmute and then remute yourselves appropriately. So we're off to a decent start. We also have some staff on board, and I'll ask you all to introduce yourselves when you get called on to come up to speak. The first item on the agenda is to review and approve the minutes from our December 19th, 2019 meeting. Those should have been emailed around to you. I hope you all had a chance to take a look at them. If you haven't, take a couple minutes and please go through them. When you feel like you've had a chance, subject to any corrections or additions, I would entertain a motion to approve those minutes.
I would move to approve the minutes.
I'd
Thank you.
second that motion.
Thank you. We have a motion in 2 seconds, so that counts twice. Any discussion on the minutes or additional changes or anything to them? If not, all in favor of approving the minutes, please say aye.
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 Thank you. Any opposed? Thank you. Minutes then are approved. We'll move on to the first substantive item. That's an update on the adult compact. I'm going to hand this over to Mary Kay to please kind of walk us through that with her and her court services staff.
Thank you, Justin. So since the council met last in December, there have been a few things going on in Indiana and across the nation related to compact. And we'll talk specifically both in the adult and juvenile updates about the impact of COVID-19 and the pandemic conditions on compact operations. So the first thing I want to provide the council an update on is specifically states' responses to COVID-19. And I'm discussing the adult side, at least in part in the context of my role with the Adult National Compact, which is, I not only serve as Indiana's Commissioner for Adult and Juvenile, but I'm the chair of the Rules Committee for the Adult Interstate Compact, the ICAOS, and then that also makes me a member of the Executive Committee. So to the degree that there are some changes that have happened nationally regarding rules and COVID-19, on the adult side, I've been pretty involved in some of those conversations. And so we'll talk a little bit about what this looks like on the adult and juvenile side throughout the report. But specifically, when we're looking at the impact of COVID-19 on state operations, all of our organizations and agencies have been impacted in multiple ways, and compact is not accepted from that. So what we found at the national level on both the adult and juvenile side, that states were sort of unilaterally informing the national offices that they were not able to perform certain compact functions, either they had staffing issues, or there were issues with getting information from the locals, or there was transport issues. And so they were in effect just putting the national office and the other member states on notice that we're not doing these things. We can't do these things. We have an executive order in place that's preventing us from executing our compact duties. So FYI is basically how it was going. And while everyone certainly understood that that was a challenge, there really wasn't a mechanism in place to waive any of those requirements. There's no ability to forgive any of the compact standards. Obviously, this is a public safety issue. So we wanted to make sure that counties and states really understood that they still maintained an obligation to, in good faith, perform their duties under the compact. But we also recognized that, in many circumstances, we have states who have, very localized conditions such as hurricanes and things like that, that prevent them from temporarily being able to fulfill their functions. But this was unique in the sense that it was nationwide in varying degrees. It was coming in waves to different states, and then it was going to persist for a long time. So what both the adult and juvenile compacts did, and you have this in your rules, is they held emergency meetings to take a look at the rules for Interstate Compact to see what the national offices can do to help to assist the states in getting through this time. So ultimately what they ended up doing, and Jenny's bringing the rule language up on the screens for both the adult and juvenile, is the national offices and the actual commissions agreed to suspend the enforcement of the compact rules, meaning that it would have to be a pretty egregious situation for a county or for a complaint to be lodged against a state for the national offices on either the adult or juvenile side to really investigate and hold a state accountable for that complaint under the pandemic conditions. Not impossible, but sort of a relaxed standard or time frame for reviewing any complaints that may be filed. So the idea being is that we understand that counties and states are having a hard time filling some of these functions. The areas in which the functions probably suffered the most was in the area of transfers and acceptance, as well as transportation and extradition of individuals who were picked up in other states. So in recognition of the fact that it was problematic, we wanted to give the states more time to work through some of these issues, meaning mostly the timelines were with what was going to be suspended in rule enforcement. If you were supposed to do something within 30 days, there was an acknowledgement there was a hardship, and that enforcing the 30-day requirement was going to be waived or suspended during this time frame of national and state emergencies. It did not relieve the counties and states any responsibility of actually continuing to make an effort to perform those functions. So if you couldn't do it in 30 days, you were expected to try to do it within 45 or 60 days. So that was a really critical component of the rule amendments, and making states understand you still have these obligations, but we're going to give you a break on the timelines. So this emergency rule was adopted in April for both the adult and juvenile compact. They are different slightly in language. The effect is the same. When there is a declaration of a national or state emergency, both councils have the ability by full commission vote to suspend enforcement of the rules or designate the executive committee of both of those groups to suspend the enforcement of these rules. There are certain parameters that are in place. It is limited to the requirements under the rule. Both groups agree that you do not have the ability to waive any statutory requirements, but this at least gives the states a little bit of breathing room and some ability to operate, again, in good faith during pandemic conditions without being concerned that you're going to be subject to complaints and subsequent fines. So this is currently in effect for both the adult and juvenile side of things, and it will cease to be in effect once the emergency conditions subside, either at the state and or national level. There is some capacity for the executive committees for both the adult and juvenile commissions to make those determinations if there's a variation in what is happening across the country from a regional perspective, or the executive committee on either the adult or the juvenile side could and the suspension of enforcement of rules on their own if they saw fit. So we think this is a good compromise. When we first entered into the pandemic conditions, we noticed that a lot of states had adopted or given notice to the national office that they were making changes in their day-to-day operations. And both the juvenile and the adult published that on their website. One thing I will note is that Indiana, our office between probation and parole never submitted any restrictions to either national office, just because we really wanted to work with the counties to make sure that they were doing all that they could to keep cases moving, making sure local offices were in compliance, and helping them through any of the challenges that they were seeing. So I think our teams on the probation and parole side did a really good job being responsive to the concerns of the counties, helping them work through issues. So we never submitted any kind of restrictions to the national office, meaning that we never had to tell them that we were resuming operations either. So we think that's a good thing. I think we were probably uniquely situated. There were only a handful of states that took that approach. But even those that did submit restrictions to the national offices many of them have walked those back, and they now are reporting that they're operating at full capacity. So I think we're in a good position. I would defer to Nita and April and Taran and Joel to see if they had any comments about any of that, or if that's something they want to cover later in the report about our local offices' ability to comply under pandemic conditions. But overall, I think Indiana did really, really well. So the only other thing that I will say related to the pandemic conditions that's not reflected in these rules, at least on the adult side, there is a discussion going on about fees and dues for 2022. Indiana has paid our 2021 dues, which were due July 1st, will take us through June 30th of 2021. We have paid those on both the adult and juvenile side, as have many states, but there's conversations going on about reducing dues on the adult side for fiscal year 2022 because of budget crunches due to the pandemic. So it's possible that there could be an overall reduction in the dues on the adult side, possibly discussions on the juvenile side. Right now, our dues to participate in the National Compact run around, I think, $26,000 for the adult, maybe something similar for the juvenile. It's a formula based upon usage of the compact, meaning how many cases are coming in and out of your state. So I think we're in a good position right now because we have paid our dues. Some states really are facing pressure to request reduction in dues to the national office. And what that ultimately will result in, if there is a reduction in dues or states are unable to pay, is the reduction in the services and staffing that's available to us to the national office. So both the adult and juvenile offices have some breathing room in their budgets to take at least a temporary hit on dues. It's not something that it can sustain long term, but they are considering it right now. So that's the extent of my report on the rule amendments. And then I will keep the group posted if there's any changes on dues requirements.
Thank you, Mary Kay. For any members of the public who are watching the live stream, I realize that that document probably looked small as a shared screen document on the live screen. That will be posted to the Interstate Compact state councils or through the court's website, so members of the public can see that full document. Mary Kay, on the emergency rule, I just had one question. Is it contemplated that we as the state council are supposed to petition the commissions in the event our governor declares an emergency? Obviously, everybody's under one now, but if something else comes up, you throw out the hurricane thing, or if there's a second spike or something particular to our state, are we supposed to do a formal process to seek that?
Yes, if we did wish to receive some sort of consideration, we would need to submit to the national offices the authority under which we're operating, the authority under which we're suspending certain operations, such as transport or something like that. It is subject to review. There is some expectation that there is a real and true emergency. There is a real and true authority for states to suspend some of their operations. So we would have to submit that, yes.
Okay, Thank you. Does anybody else have any questions on what Mary Kay just presented? Okay. Then if we want to move on to the response, particularly here and at the local levels, April and Turan. Whichever one of you.
Hello, my name is, can you hear me? Okay. Hi, my name is April Simmons, and I do the incoming cases for Indiana Compact Office. So for incoming cases, most of our probation departments were closed due to COVID-19. So we had to work with them and to become creative and think out of the box how we will continue to meet our compliance with ICAO's rules. We came up with an idea with our local that in order to continue to conduct home visits, our locals were meeting with local sheriff's department, and we were asking them to do home checks or welfare checks in order for us to continue to verify our offenders' addresses and to ensure that they live where they say they live. And also for appointments, they were closed as well to the public. So for face-to-face appointments, they were creative and they continued to call their offenders, and they would do phone visits, either bi-weekly or weekly or monthly, depending on their risk level at the local offices. They would look into that, and we would go from there. So we have not had any issues in regard to not meeting those compliances. And all of our locals are adjusting well to it, and they are happy that they are able to continue to meet with the requirements for ICAOs and for Compact. Does anybody have any questions about that? Okay, then defer to Ran, and she'll do outgoing.
Actually, April, I changed my mind. I do have a quick question.
Yes, ma'am.
How long will they continue using these modified processes of doing phone visits instead of in-person visits?
Well, most offices have started to open up. They are also on the modified opening schedule. So July 7th is when the entire state opens up from the governor's the emergency. So after that, then that's when they'll continue to do their standard home visits by their as scheduled, and then they'll do their reporting in person.
Do you know if there's any intention to continue to use phone or maybe employ technology like Zoom as a way to monitor people or check in with them?
I know for Marion County, they've been using that, but I'm not sure for the other counties if they're going to continue with that. But I do know.
Oh, I didn't mean to interrupt you. I'm sorry.
No, go ahead. I'm sorry.
I only ask because I've been trying to, think about, what are some of the good things that, if we can find anything good out of COVID, some practices that maybe we should carry forward. And I would think using technology like phones, like Zoom, could be really good to continue to employ when appropriate. I'm not saying there should never be an in-person visit, because certainly if it's permissible, that's a good thing as well. But I know that many, when I think about public defender clients, people have, transportation issues, meaning no transportation or no funds for gas or childcare issues, a whole host of issues that make it difficult for people to comply with in-person visits. And it would just seem like to increase compliance, to increase efficiency, it might be helpful to keep those tools. I know that isn't up to you, but I'm just sharing that as all of us as stakeholders have these things in mind, it might be helpful to keep seeing these tools being used even as we go forward.
Yeah, we can reach out to our locals and see how they, if that's something that they're open to doing. And we can get back if that's, if you would like to know the information.
I would, yeah, thank you.
Mm-hmm.
My name is Taran Blazier. I'm the Deputy Compact Administrator for Probation and through the Indiana Office of Court Services. So I usually handle the outgoing cases from our state. Since COVID-19 hit, they also have had to be creative in how they get these cases out, as many departments, as you know, suspended in-person meetings almost immediately. So, but thankfully, everyone has that emergency rule, and we've been very considerate of others, and they've been considerate of us. So we've had to mail and fax forms to get them signed. Thankfully, offenders and probation departments have been able to work together and get those things done. We didn't have any overdue documents really during this time. We got our audit results. A mini audit was done, and Indiana still maintained their upper 90 mark there. I think we had 1 or 2 maybe that were the upper 80s, but still well above the national average. So we're very thankful for that. One of the issues we kind of struggled through but made it out okay was the issue of retaking, which is when an offender violates probation. Now we are required to take them back. That happens when a state issues a warrant for an offender. A lot of states, including Indiana, had local sheriffs who were uneasy about transporting offenders. So working on an individual basis, we were able to get some of those warrants recalled that weren't for violent offenders and order the offender to return back to Indiana, which most of them did. If they didn't, then a warrant was reissued. But those issues have kind of subsided, and everyone who has a warrant is being retaken for the most part by our local sheriff. How we kind of got around having so many warrants to begin with was reduce the number of violation reports that were submitted and that we received. So if states would normally violate and ask for a warrant on something that wasn't necessarily violent or needing to go right away, but the rule allowed it, they would issue those warrants and we would have to retake them. So a lot of that stopped, which is a positive outcome. We have a lot less warrants, in my opinion, for unnecessary reasons. And we're only actually retaking those ones that really need to be arrested, apprehended, and brought back. So we're back up and running when it comes to retaking, but we did slow that down a little bit. Violation reports seem to be a little more frequent now that everyone has gotten their groove and we're responding on time, and we haven't gotten any complaints about our offenders on the probation side sitting in jail longer than the 30 days that the rules allow for. But we're pretty proud of that. Our probation officers have completely risen to the occasion, working from home, doing whatever they could to get these transfers out, to get these offenders supervised in their home jurisdictions. But I will also turn it over to Joel because he is the DCA on the parole side, and so he can talk about their operations there.
I am Joel Gruber. I'm the Deputy Compact Administrator for Parole. I work out of the Department of Correction. We also had to modify things. We closed our parole offices for a few months where parolees weren't allowed there, agents weren't allowed in. All of our contact was done by phone or in the public. Our modified home contacts actually went up because we tried to keep tabs on everyone better, just to make sure that they were where they were supposed to be and that they were remaining in good health throughout the pandemic. These modified contacts basically consisted of agents going to places of work or the residents, calling the offender by phone, having them come to the front door, out of the porch. That way they could have a visual of the offender and conduct the interview via phone or through the car window. We're reopening our parole offices in phases now. It's back open for the agents, and I believe on July 6th, they'll start having parolee interviews by appointment only at the district offices. But similar to what Tran was saying, we've been able to maintain our compliance. We've still been doing all of our transfers and everything as usual. We also put it out there because we didn't want to violate our own offenders if we didn't have to. So the same was, put out for Interstate Compact as well. We didn't want to violate Interstate Compact offenders because we knew how much of a stress it was going to be for other states to extradite. Indiana Parole didn't really have that issue because we don't use a contract service to do any of our extraditions. We do all of ours ourselves. So as far as retaking, I don't know of any issues that we had with that during this pandemic.
Thanks, Joel. Anybody have any questions, at least specific to the COVID-19 response here?
Hi, Justin. I had a question.
Go ahead.
Yeah, this is Chris, and I had a question for Taran. And help refresh my memory. You talked about kind of that decision between a warrant and maybe a summons, and I'm not sure under the compact whether that's discretionary either for probation officers or for a particular judge. So if you could help refresh my memory on that.
So normally there are certain rules that require, if certain actions are taken, a warrant must be issued. So
Okay.
those would be for absconding or a new felony or violent conviction. Those are automatic warrant from the sending state. If we were the sending state, we would have to issue a nationwide no bond warrant for that offender. And when they are apprehended, we would have to extradite them back.
Okay.
There are also other instances where we can issue a warrant. So if an offender has 10 technical violations and they submit that on a violation, once they submit anything on a violation report, we are obligated to then bring that offender back to Indiana. So what some states have been doing, Indiana included, is instead of putting those technical violations on an actual violation report, which would then trigger the retaking process, they have been advised to put them on a progress report, which gives the sending state discretion on how they deal with those. So in the instance of this last 3 or 4 months, they would put it all on a progress report and say something along the lines of, we would normally submit this on a violation report. Due to the current circumstances, we're submitting it on a progress report because we understand each state is kind of in a difficult situation. Local officers on our end see that and know, okay, this isn't just a regular progress report. They really want us to retake them, but they're being courteous and allowing us the option to not do so with a warrant. We can just order them to return and do it that way at our own pace. So there's where the discretion is. It's on the person who's entering the conditions, whether the violations, whether it's on a violation report or on a progress report. So the discretion comes from the supervising officer. Now, when we have someone who has been taken into custody and a local sheriff has some apprehension about bringing that person back, they will contact us and we will work that out with those 2 counties. We'll say they're not really wanting to either take them into custody or they don't want to extradite them because of that emergency rule and some just cooperation between states. Depending on the situation, there was no blanket response. Depending on that situation, we were able to get that offender back. If we wanted them to still be extradited, that still had to take place. But if 2 states were willing to work it out, then we could arrange something where the offender was ordered to return. They came and reported to the jail in Indiana, or they reported to their probation officer by phone once they got here, or that something else happened, put on home detention in some states. They were putting them on electronic monitoring instead of bringing them to the jail.
Thanks, Taran. That's really helpful, and maybe another way to, if there are areas where warrants can be reduced moving forward, based on the circumstances. So that could be a good takeaway.
Yes.
Thanks.
I have kind of a similar question. I don't know for April or Taran or Joel, you all sort of talked about doing different versions, a little bit what Bernice was getting at. You talked about doing different ways of contacting, or in-home visits, doing those remotely. Is there a rule that would normally mandate those be in person and we're just sort of working around it? Or does the form of contact, is that left up to us?
The form of contact is the level of supervision, basically. So the receiving state sets that for each offender that comes in. So for Indiana, the counties would set how they supervise. We don't tell them how they are to make contact with offenders. The rules just say, in certain rules, that you have to have contact. It doesn't say how. We can't dictate how they supervise offenders. That's just a local, for probation, that's a local county policy.
Right. Same with Department of Correction. It was just a modified way of, we have a certain number of contacts we have to have with parolees, depending on their risk level and supervision level. And it was just a modified way of conducting our supervision with departmental policies and not necessarily with the contact.
Okay.
Justin, if I could add, there's a treat him as you treat your own doctrine So if you are providing in-person visits for your own people, then you would do the same for the transfers in. If you have adjusted and you've moved to remote supervision, you would do the same thing for your compact people, just so that people are being treated in the same way and that people coming into the jurisdiction are not held to a more restrictive standard than individuals who were sentenced in that state.
And I'll just
So
add, it has allowed, honestly, for a smoother movement of offenders, believe it or not. We're not getting caught up in the logistics of everything, I hate to say the legality, but just the paperwork of everything, holding offenders back from where they should be. Now, this isn't for offenders who are moving on a discretionary basis. These are people who should be in their home state. So it has allowed for a smoother operation for sure. And as far as I know from Indiana's standpoint, we haven't lost anybody yet. So thankful for that. And the paperwork is catching up to them eventually. And everyone is under supervision, but it has allowed those offenders to move at a smoother rate than ever, a much smoother rate.
Okay, good. I was just curious about how the compact rules worked, whether it imposed some sort of structure that was less flexible than we would be able to normally use. And it sounds like that's not the case. It gives that flexibility to the counties. So thank you. If there's no other questions on that, Taran, I'll leave it with you to talk about training, please.
So as everything else, our justice services meeting our in-person meeting was canceled. And during that meeting is when we have a large turnout for our interstate compact sessions during that meeting. We have a lot of information that we get out to them on a yearly basis. A lot of them rely on that for their refreshers or introduction to interstate compact. So on the adult side, we're working on how we're going to get that information out to them in a timely manner. What I've started to do is regular emails to them, trying not to inundate them with a lot of information at once on the new rules that were passed in April, things they should know, how to implement those rules, some ideas on how to continuing to supervise during this situation. If they need anything from us, we're trying to make it as easy for them as possible. A lot of them are very receptive, and I've seen that they've started to implement some of those changes we're emailing them about. And they're even offering suggestions on things to add to future emails for other counties to benefit from as well. So that's how we're going to train them for now until we can figure out a way to have an online or a WebEx or some type of meeting. I know the national office has offered to host those for us where we could get everyone on a call, and they will set it up for us, and they will have someone from their office on the line. So I'm still working on when and how we're going to get that done for them.
Any questions from anyone on that? I know we're all kind of in the same boat when it comes to those sorts of training and educational events. Thanks, Taran. April, compliance?
We're continuing to run compliance reports, and all of our counties are doing well with all the reports. We're running progress reports, case closure notices, notice of arrivals, notice of departures, and they, in all categories, we're either exceeding the national average or we're meeting it. So the only two concerns that we had were notice of departures and notice of arrivals. And those were not concerns where there's a security issue, but because, like Taran said, the paperwork is the people are going before the paperwork, and the people are having to catch up with the paperwork. So submitting the notice of arrivals that the offender has arrived in another state, or the notice of departure saying that they have left the state, were a little bit delayed, but we've been reaching out with our locals and making sure that they're submitting those, and they're responding quickly, and they're all submitted in a timely manner, and we're continuing to meet our expectations in all those levels.
Well done, staff.
Thanks, April. Anything else on the compliance side?
No, Taran, do you have anything? Or Anita?
Okay. Not then, Taran, you want to talk about the annual business meeting?
So this year, our annual business meeting was supposed to be in Wisconsin, I believe. And that also has been canceled, the in-person. Yesterday, Joel and I were on the DCA call and we got to see the agenda for the virtual meeting that will take place over a few days, I believe. They're not going to have us sit down at the computer for a whole day for sessions, thankfully. They're going to break them up over several days, which I'm hoping that will give you all a better opportunity to attend, since they won't be, it won't take your whole day every day for a week. So they will get that out to us. They're still planning the DCA Institute, which is a in-depth dive into compact actions, compact work, compact activity. And if any of you have any questions, once that agenda is sent out, please don't hesitate to reach out if you want to know if this is a session you should attend or might be of interest to you. And we're hoping that you and even some in your offices could sit down and watch those sessions to get a better understanding of how the compact works. But that it's still going to take place in the fall, and they're going to get that information out to us as soon as they can.
Thank you. Any questions on the business meeting or anything else on the adult compact before we move on to the juvenile side? Okay, thanks. For the juvenile compact update, Nita, I think you basically have this whole section, right? And you're muted. Told you.
I am Nita Wright. I am the Deputy Compact Administrator for the Juvenile Compact. And COVID-19 has had an impact on everyone, but not all bad things came out of it. With the emergency rule that was passed, even though it was passed, it put pressure on us to keep with compliance. We never needed to have to have any special stipulations because we remained in compliance, because we already have a backup system for Indiana. For our day-to-day operations, we implement a backup system for our counties in the event that a user is out of office. So just for our day-to-day compliance. So having that normal backup system helped us to smoothly transition into the, when the pandemic hit, it helped us to smoothly transition into a new backup system. So when it was time to have a new normal, we were already in that system. So we're used to having to go into backup mode. So fortunately for us, even though they had to pass an emergency rule, we didn't have to utilize that. So we're very proud of that because Indiana already takes into account those things, the what ifs, and we prepare for those ahead of time. And so we're proud to say that Indiana continues to maintain their compliance. We look ahead of, we are a proactive state. And so with that, I like to go ahead and discuss how we were creative with the impact of COVID. One of the biggest things that our counties, the issues that our counties were afraid of happening is that they have to have home evaluations for transfers. So they were afraid of not being able to meet compliance by having those face-to-face visits. The thing that we encourage them to do is to continue with those visits, but in a more creative way. The takeaway from that is that we were able to implement video home visits, and that we can use in the future. It not only was a positive experience, but it also sped up the process. It also allowed us to be able to use less manpower in sending individuals out into the field. It shortened the time that it takes to produce a home evaluation. So that was one of the positive things that took place during COVID. So instead of having to arrange a time that a family could meet on both of the PO schedule and the family schedule, they could quickly sit down at a computer, they could log in, and they could do a show of the home through a video chat. Never leaving the office, never jeopardizing anyone's safety. And so that was a new experience that we're going to continue with the future. So to address something that Bernice mentioned, as far as something that we can take into the future, that's one of the positives that we took away with that. Also, not only was that a positive, but it also showed us that it increased our compliance. We've had better compliance during COVID before COVID hit. The turnaround for home evaluations increased with the use of the video home evaluations. We changed the way some of our offenders were reporting. We used kiosk reporting. So we did phone reporting. We put technology to use. The advances of technology allowed us to use more creative ways. Anytime you use our juvenile database system, you have to have Adobe as one of the requirements to use the system. With Adobe comes the electronic signature. So instead of having to have face-to-face appointments in person, we were allowed to use the electronic signatures, having documents sent out by email or fax documents, and having those returned with electronic signatures, which are validated by the Adobe validation system. So that also sped up the processing of having to set appointments around parental work schedules, school schedules. And even though schools were closed during the COVID, it was still a process to getting time to get that done and maintaining schedules with compliance of getting documents turned in at a certain time. So this was really a positive experience for us versus a negative experience. So we took away a lot from this, and this actually increased Indiana's compliance numbers. Another thing that we were able to do is, along with the use of technology, our current system, our current database system, we are going to retire that system. In understanding that our current system is no longer viable for us, we know that in implementing the new system, utilizing technology during COVID also gave new ideas that will be implemented in our upcoming system. So these things that we did not know in producing the new system, now we have new ideas that also are going to move over into the new system that we did not have before. So that's another takeaway, that COVID-19 also helped to enhance our experience for our new system. So there were some things that we did not know because we had not experienced, but now that we've experienced them, they will now move on to our new system, and they will be enhanced and will, going forward, be a part of our new system. So yes, we will take these things into our future, and they will enhance not only our experience, but everyone across the country.
Anybody have any questions on either the emergency rule, which is, Mary Kay largely already touched on, or the juvenile side of our COVID response? Okay. Thank you, Nita. You want to go on to the training?
Yes. This year, our juvenile ABM will not be in person. A lot of our training is received during that time. Instead of implementing a lot of new training sessions, we're holding back until the web-based trainings that we will produce in August. We're going to execute trainings for the new system during that time. We will be implementing trainings for the new system. So we're going to incorporate a lot of the trainings that we want our field to have at that time. So we have not released a lot of new information because we don't want to bog them down with information that will confuse them when we're implementing new information for the new system. So we haven't had a lot of new information going out. We've only touched bases on like cleanup for the old system. Right now, Indiana's in the process of cleaning up our old system, cleaning up records. So the only thing as far as training we're doing is training them on how to clean up their records, cleaning up their files, cleaning up their users. Any new training will be implemented in August, and new information will be coming out about that. We will be sending out information pretty soon about how individuals can take part in those trainings. And we will also be sending out information fairly quickly in July, mid-July, about how anyone can register for the ABM sessions, which more people will be afforded the opportunity since we are not having an in-person session in Vermont, and which allows more of our local users to participate since there will not be an expense of everyone to travel to Vermont. which is a good thing for all of us because no one will have the expense to pay for that. So most of our users will have that training that we are afforded. So we will have information about that coming out in probably about 2 weeks.
Thank you. And there's no questions on that. You can go right into the compliance update.
Since COVID-19, we have maintained compliance. We have actually excelled in our compliance. We have met all of our goals for home evaluations. If there have been any issues, we have quickly resolved those. We've had workarounds. All of our counties went to remote at-home work due to not having face-to-face contact. Our officers were either working remotely from off-site locations. So all of their contact was either electronic by phone, recording video. We were still able to maintain compliance with increased compliance reporting. So we are doing very well, maintaining compliance and with future prospects of future implementations going forward.
Thank you, Nita. And there's no questions on the juvenile compliance. You've touched on it a couple times, but you want to talk a little more about the Unity update and your new system?
Yes. We will be retiring JIDs December 2020. At the same time, we will simultaneously go live with our new Unity system December of this year. Starting in July, the compact offices around the state and the country will start their training. In August, all of the local offices will have the opportunity to start their training on the new system. The system is currently still in development, but it is nearing the end of that development. Training modules are nearing the end of their development as well. Testing is simultaneously going on as development is progressing. There is a BA team that is checking the system as they're developing the system. So if there's any issues, they're testing, checking, correcting along the way. So that has maintained its timeline and it will go live December 2020. We were going to introduce that during the ABM of this year, doing a live demonstration. I believe they will still do some type of demonstration, not as thorough as it would have been during the ABM, but they will still do some type of demonstration during the web-based seminars that they're going to introduce. One of the good things that I would like to say about this new system, we are very proud about it. Anything that you can think of that would have been a hindrance with our old system that is outdated, we have tried to implement in the new system. It has taken into account all the advances of technology. It is very user-friendly. It is agnostic. It can be used on any platform, cell phone, tablet. It allows the opportunity for judges to quickly sign a document on a tablet in conferences. If a lot of people work simultaneously on projects while they're doing meetings, so it allows them to continue to complete projects, maintain compliance while multitasking. And that is one of the things that our current system does not do. Another thing is the main purpose of the compact is community safety. With a lot of turnover in the field, training new users to learn a new system, that can create a gap in community safety. The time it takes to train new users, having to always have a backup system. This system we created to have such something like a TurboTax per se, TurboTax for dummies, if you will, training modules. The modules are quick, brief, to the point that you wouldn't need instruction to learn how to use the system. You could walk up to the system, learn it on your own, and immediately start working the system. It walks you through step by step as you're doing the system. So if a new user was hired, they can start immediately working in the system, which stops that gap from the time it would take a new user to get trained on the system, to getting their own cases into the system, to keeping cases moving, to helping the county to meet compliance. So that's one of the great benefits of the system. And it not just benefits those who created the system, it benefits everyone using the system. And that was one of the things that our current system does not do. So everyone benefits from the system. And that was the greatest thing that we all looked forward to. So we're all proud of the system. We will all benefit from the system. And it makes everything great for those who will use the system.
Thank you, Nita. Anything else on the annual business meeting?
Other than we're sad that we won't be in Vermont this year. That is all.
Okay, thank you. Any questions generally on the juvenile compact? We have a couple things after this that we'll want to make sure we get votes on. And Senator Sandlin, I know you have to step out here in a little bit, so I'd like to get through those with everyone we can. So next is a legislative update. I'm going to turn it over to Mary Kay, but Senator Sandlin, obviously, whenever you want to jump in on this, please do so.
Thank you, Justin. Last year, Senator Sandlin was kind enough to agree to author a bill on behalf of the compact to make an adjustment to the county transportation fund. We had realized last year through some inquiries from counties that there was a limitation in specifically what entity locally could access the county transportation fund when they're looking at extradition of compact offenders. So Senator Sandlin authored a bill in last year. It did not get a hearing. I think last year was a short session, things moved quickly. But my hope is, Senator Sandlin, that you would be willing to re-up and reauthor that bill, as well as help us shore up some language that was discovered when Mark Goodpasser was doing the fiscal note on this bill. We need to make some adjustments on actually the application fee. And so if the group would like to move forward with this and Senator Sandlin is willing, our staff can work with Senator Sandlin to draft that new language, as well as work with him to refile this existing language that was in the 2020 version of Senate Bill 317. So Senator Sandlin, I don't know if you have any comments about that or any reaction to that, but we would appreciate your assistance on that if you're willing.
Yes, I think that it should be resubmitted and updated so we can get those changes over to LSA and have them start looking at it.
Does anybody have any questions or input on that? I don't know if we need a formal motion, but if there's no objection, I would have Mary Kay's staff work with Senator Sandlin, Senator, whatever you might need as far as assistance from our folks. And if later down the road we need a formal letter of support, Mary Kay, I don't know if we'd come back and ask for that, but anyone have any input or thoughts on that? Okay. Mary Kay, yeah, then if you want to put some thoughts together and help Senator Sandlin. Senator Sandlin, thank you for taking that back again. The next item we'll stay with Mary Kay, the NCIC access for IOCS staff.
Yes, thank you. At the last meeting, the group talked about the limitations that we have within our state office, our state compact office with NCIC access. The Department of Correction and Joel and his team are really helpful working with Nita and April and Taran on getting NCIC access for probation individuals. But it is a limitation. It's a burden on Joel's team, and sometimes it's a timing issue in getting information. So we have talked about, as a council, making a request to the state police to get IDAX access. So that was a discussion at our December meeting, and I was tasked to reach out to the state police. I have not done that, but I do think that there's some things that have occurred in the last couple of months that may strengthen our argument or strengthen our case to the state police as we make that request. Because as we discussed at the last meeting, we've made that request in the past, and it was determined that we did not meet the criteria for the state office for compact did not meet the criteria as a law enforcement or criminal justice agency. So since our December meeting, the National Adult Office requested an ORI from the FBI, which is essentially the ability to access the NCIC information from the national office. And that was in their capacity to monitor compliance with compact warrant requirements. They were denied access on the basis that they are not a criminal justice agency performing a criminal justice function as a primary function. So the letter that I provided you does indicate sort of the standard of review that the FBI uses for this. We can expect that ISP would offer a similar standard of review. So we know exactly, how we would want to phrase the request to state police in hopes of being successful. The other component of this letter is that it does reference as an option for the national office to work with their state supervision agencies to obtain information. So I think there's some acknowledgement that the state supervision agencies should be able to have access to this, and we know DOC does in their function with parole and facilities. But what we're looking for is for the court side of things. And here in Indiana, with probation being a court function, we're hopeful that we can use this to help substantiate the request. So my proposal moving forward is to craft a letter and perhaps maybe enlisting at least one or two of the council members to assist us with the language. Chris, your assistance may be particularly helpful. And then if the council members are also willing, I would like to propose that the council Justin not only submitted on behalf of the council as chair, but if the council members are willing to also be signatories on that letter, just to show the broad base of support that we have from the individual council members and the constituents that you all represent. I think that would also be very helpful. So if that is something that the group is agreeable to, we will work as staff to draft that request and then work to get that submitted to ISP.
Anybody have any questions or thoughts on that, Chris, in particular?
Definitely happy to assist, whatever that might look like. Yeah, I read the letter, Mary Kay, and one thought I had was to, seek a legislative solution and just have the General Assembly say the ICAOS is a criminal justice agency. But I guess in reading the letter, that may not be an effective end around.
Well, I think, Chris, to your point, I think the limitations that the national office has is that they are in no way directly involved with supervision of offenders. And theirs was really just for the purpose of monitoring state compliance with the compact requirements. I think we're in a better position, even though we are a state office, that the individuals run through our office for the purpose of supervision and our connection with the locals. And the fact that our office, Office of Court Services and the Supreme Court oversees probation generally, but that the council has been given the authority and the responsibility to ensure compliance with these national rules, which are related to the supervision of offenders. So we're hopeful we can make that an effective argument for us to be granted access. So we'll hopefully be able to work with you on that and get some feedback from the other members on how we can do that.
Happy to help.
Thank you. Thank you.
It's another one. I don't know that we need a formal motion on it, but you all will see the letter. Is there any other comment or input on that? Otherwise, Mary Kay and Chris can work on that language, and it'll come around to everyone as an official letter at some point. Okay. Hearing none. Thank you. Thank you to both of you. Next is other business. If there's something else that any other member wants to bring up, address, any concerns, either COVID related particularly, or moving into the sort of the legislative season, happy to hear those and we can talk about them. It's not a test, there's no requirement. So hearing none, thank you. Next meeting dates. Right now we have September 25th, 2020. We do have some scheduling conflicts on that date. That's a Friday. What we'd like to suggest is the day before, Thursday, September 24th at 10:30. If you don't know off the top of your head, we can send this around as an invite or a poll to try and pick that, but that's what we're looking at. If someone knows that they have an immediate sort of deal breaker, feel free to throw your hand up now, but we can shoot that around. Judge Kenworthy does.
Yeah, I have Chin's docket all day Thursdays, including the lunch break, so I would not be available on Thursdays.
Okay. Anyone else off the top of their heads? Okay, we'll send that around, see if we can still get a quorum or if there's another time where we can get everybody. The December meeting, we don't have a date for. What the staff had suggested was Thursday, December 10th, again at 10:30. And again, we can send out a poll to see if these particularly work, but if someone looks at that and thinks immediately, I can't do that, just let us know. So I'm getting chat messages that April Debris will send out a poll to all of you, so don't worry about it now. Anything else before we adjourn? I think we're at the end of the agenda. 1 hour and 1 minute, which is a little over my standard. So if nothing else, thank you everybody for taking the time. I hope you're all doing well, and we will talk to you again at least in September. Thanks.
Bye, thank you. Bye, everybody.